The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. This morning, we have 4 cases for submission, but before I go there, I'd like to say that Justice Cady had a matter come up this morning, and he will not be joining us, but he will be participating in these cases. The four cases to be submitted this morning are Denison Municipal Utilities versus the Iowa Workers' Compensation Commissioner, State of Iowa versus McKinley, K. Decker versus the Iowa State Board of Tax Review and Cable One, Inc., and State of Iowa versus Halverson. The first 3 cases will be submitted orally, and the last case will be submitted non-orally, and we're ready to hear the argument from Ms. Berger.
May it please the court, Mr. Scieszinski. My name is Julie Berger. I'm here with the Attorney General's office, and I represent the Workers' Compensation Commissioner in this matter. This case comes before the court on undisputed facts. What happened is Kevin Fink, a claimant, alleged a work injury and filed a petition for alternate care before the Workers' Compensation Commissioner. Upon receiving that petition, the Workers' Compensation Commissioner sent out a letter to his employer, Denison Municipal Utilities, requesting that a first report of injury be filed pursuant to Iowa Code Section 8612. That notice indicate failure to file that first report of injury within 30 days would result in a $1,000 fine being assessed upon a hearing. In this case, Denison did not file the first report of injury as requested by the Commissioner. A hearing was held before the Commissioner regarding Denison's reasons why they did not file that first report. What the testimony before the Commissioner was that this injury did not meet the requirements of 8611, those requirements being that claimant would have missed time from work, 4 days from work, or have a permanent disability. So it's Denison's position that it was not required under 8611 to file that first report of injury. Therefore, they did not file that. The Commissioner rejected that argument, finding that it had authority under 8612 to request a first report of injury and then assess the $1,000 fine. The case went to the district court. District court reversed. It's the Commissioner's position that the district court erred in finding that the Commissioner had no authority under 8612 to request a first report of injury.
Ms. Berger, do we give deference to the Commissioner's interpretation of 8612, or do we interpret it essentially de novo?
I would assert that you give deference to the Commissioner's interpretation of their statute. The Commissioner's...
Well, why? Under our line of cases, you don't just simply give deference because it's a statute that they administer.
It's a statute that, you're correct, that they administer, but it's the interpretation that the Commissioners relied upon that I think the deference ought to be given to. The Commissioner's functions are set forth in 876 of the Iowa Administrative Code 1.1. In addition to the adjudication function, the Commissioner has compliance duties, and with those compliance duties, the Commissioner must monitor cases, must prepare reports, must respond to inquiries. And to track inquiries, the Commissioner under 8612 has the ability to request upon written demand that an employer file a first report of injury. That requirement is separate from 8611, as I indicated regarding the facts. 8611.
All right, Ms. Berger, as I read 8612, it says the Commissioner can require any employer to file a report, and there's 3 situations: required by 8611, required by 8613, or required by agency rule. Which of these do you contend the requested report falls under?
The agency rule, 876 Iowa Administrative Code 3.1 is an administrative rule that allows the Commissioner, upon written demand, to request that an employer file a first report of injury. The language in the administrative rule is much similar to 8612. So that administrative rule gives the authority for the
Well,
commission.
I mean, I'm aware of an administrative rule that says if there's a petition filed, an original notice and petition that alleges an injury, that's in 876 3.1. That isn't what we have here, is it? We
Yeah.
we have instead a petition for alternate medical care, right?
We do have a petition for alternate medical care, which would be different from a petition
Yeah.
for,
Okay. All right. Thank you.
but I certainly think that under the agency rule, that 3.1 gives the authority to demand a first report of injury from the employer.
If that rule wasn't on the books, would we be here today?
Probably not. I mean, as it sits here, I should probably back off that. I do think 8612 gives the commissioner authority, independent of the rule, or working with the rule, to request that first report of injury. What I think we need to know, that first report of injury simply indicates a claimant's name, the date of alleged injury, and the employer. It cannot be used in court under 8611. It is simply a tracking device.
Why does the commissioner need a first report of injury to process a request for alternate care when the employer says there's no injury here? So you don't get alternate care, and when the employer says there's no injury, you don't get alternate care. So why do you even need, why does the commissioner need that? Can't the commissioner docket it based upon the alternate care petition and process it? I mean, what does it add to the commissioner's file?
It's a tracking device. It's its ability to have, it's not just the docketing. It allows the claims analysis, the compliance officers to track that claimant and that date of injury. It is their tracking device, something similar to a docketing, but to the extent that a petition hasn't been filed, the commissioner still needs to, under its compliance duties, track those inquiries and be able to respond to those claimants.
Why didn't the commissioner pass a rule that when you, to cover the situation, if it's not clear in this statute, that when you file a request for alternate care, you have to file a document that has all the information, sort of like a civil cover sheet like we have in district court. You have to file a document that has all the information needed by the commissioner to do their compliance duties.
I believe it has in its administrative rule 3.1 that the commissioner can request that by written demand that first report of injury be filed. I think between the administrative rule 3.1 and the code section 8612 that the commissioner has authority to request that information from the employer.
Don't we have a conflict with 8611? It says you don't have to do the report if they don't miss work for more than a day. And can the rule trump the statute or impose a requirement that the statute says is optional?
Well, I think we make 8612 meaningless if we say you have to meet the requirements of 8611. We already have 8611 that says you need to file you have to file a first report in those situations. Now we have 8612 that says you don't meet the requirements of 8611, but the commissioner can request that.
I understand that argument, but one could also argue, couldn't they, that 8612 is a procedural mechanism that enables the commissioner to enforce 8611. Otherwise, it's just a mandate that's out there, whereas 8612 gives a specific procedural mechanism.
Certainly an argument could be made that is the procedure mechanism. On the other hand, I think it certainly argument can be made that it gives the authority to make that written demand absent the requirement of 8611. Your Honor, if there's no further questions from me, I would ask that the decision of the district court be reversed and that the agency decision be affirmed. Thank you.
Scieszinski?
Thank you. May it please the court, counsel? The Iowa Workers' Compensation Commission is an entity created by statute. The agency only has the authority and power given to it by the legislature. The legislature in this case has passed two statutes which you referred to already today, 86.11 and 86.12. In those statutes, the legislature specifically makes clear when a first report of injury is required to be filed by the employer. It's required to be filed if the employee misses more than 3 days of work or that there's a permanent injury. No dispute in this case that this report at issue in this case was not a report that the legislature indicated that employer.
But why wouldn't the employer file this report so the commissioner has some basis, because their whole docketing system is based upon a first report, and you've practiced long enough to know that, and I remember it when I used to do it.
Sure.
It's sort of like our cover page in civil cases. What's the harm of filing the report so the commissioner's docketing system together with their electronic system that they're trying to implement can go orderly?
Very good question. There is no real harm for the employer to file the first report of injury. And in most cases, the employer does file the first report of injury. Frankly, in this case, the adjuster made a mistake. We're talking about $1,000, normally wouldn't be bothering you, except that adjuster's job is merit-based, et cetera, and they simply made a mistake.
When you say they made a mistake, are you saying that he should have filed the first report so the commissioner could process it?
Basically, the practice of the company, if the agency requests it, whether it's required or not, this company would generally provide the information requested by the agency. So there's two different questions. One, is it something that they're required to do? And one, is it something that is there any harm for them doing? Is it something they would do anyway? And we would admit that they would do this anyway.
If the agency would waive the penalty, we wouldn't be here today, would we?
Correct. If they would waive this penalty in this particular case, we'd all go home and be fine.
And you'd file the first report?
Yes, the first report of injury now has been filed, and Mr. Fink is now actually brought a lawsuit, so we'll have some other issues involved with him as we go down the road. So, yes, Your Honor, I think the court's got to the crux of this issue, which is simply the agency is requesting information. We don't have any problem providing that information. The agency has a number of ways under the rules and the statutes to obtain information. The agency will request us to provide copies of district court appeals, copies of your appeal. They'll request us to provide that. We generally provide that anyway. It's appropriate to provide information they're requesting, but is it something they can sanction the employer or the insurance carrier for failure to do so if they make a mistake?
Could the agency require, when a request for alternate medical care is filed, could they require the employer to include with its answer, and you don't have to call it a first report, you call it anything you want, but the information contained in the first report by rule?
I think there's sections in the rules that provide that the commission can ask for information, order information, et cetera. So if they would do that, just like briefing schedules, et cetera, they can require certain matters to be submitted. I don't think there's any question the commission has the authority to do that.
So you're not contesting their authority to make you file the report. You're contesting their authority to fine you for not filing the report because the language doesn't allow it.
Right. In this particular case, under this notice for this particular failure, I don't think they have that particular authority to fine them for that. There's other mechanisms they could pursue, and if they didn't file the first report, they could pursue a number of different sanctions, including closing evidence by the employer in that particular case, et cetera, under those rules.
Would you agree that the 86 3.11, once that petition was filed, they do have the authority to request that you file that first report of injury?
Also a good question. If you look at the language of 3.1, it uses the word and, which is fairly unusual. If it would have used the word or, if it would have said first report pursuant to 8612 or original petition and notice, then I think there's an argument to be made that under that rule, they're required to file. Now, the question then becomes, under 8611 and 8612, does the commission have authority to adopt a rule beyond what the legislature has indicated, what they feel is required for a first report of injury?
But 8612 specifically gives the commissioner the authority under their agency rule to do it. It's not just 8611, it's 8610, 8611, 13, and or rule. And here's the rule that says once the petition's been filed, and they've now made the demand here, which they did, don't we have both of those elements here?
Well, I don't think you can read 8612 that broadly, that any demand for any information. If you could read 8612 to say they can demand anything and fine you for anything. I think that would be going beyond the scope of the legislative intent of the Workers' Compensation Action. So in theory, they could demand reports on OSHA. They can demand reports on other things that are way beyond what the legislature ever envisioned. So I would submit to the court that 8612 cannot be read to say any written demand by any rule passed by the commission is allowable.
Can we use hindsight to decide whether the fine was proper? Because as we know in this case, the claimant at the time he requested, I don't know if it's he or she, but at the time they requested alternative medical care, thought they had an injury that it was either a partial, permanent, or temporary disability. Now, the employer disagreed with that, but we find out in hindsight because they eventually filed a petition alleging partial permanency or temporary disability, which would require you to file a report. Can't we look at those facts to say that, well, you should have probably filed the first report because it's pretty clear from this record this case was going to be one that was going to be a contested case. And although maybe at the time you didn't know it, but only reason you didn't know it, you denied it. And if you didn't deny it, it would have been there. So can't we basically say that the fine was proper because this was a case involving the elements requiring a first report? Although we didn't find out till later, but it was that kind of case. And to say I didn't really know it because I'm the employer, because I deny it, isn't that just playing hide the ball and I'm not going to do anything till they file their petition?
Your Honor, I still don't know, even as we sit here today, whether the court would find that Mr. Fink has missed 3 days of work or that he sustained a permanent injury. So I'm not even sure the court can make that finding even today based solely on a petition that's been filed. There's been no adjudication done in that case, no evidence put in on that case, et cetera.
So it's your position that you never have to file the first report until such time it's adjudicated then? I mean, that would be your position then, and that doesn't seem right either because the first report can't be used for anything. Can't be used against you, it's just, it's more like a cover page. So it seems sort of absurd for you to say that we never have to file a first report till we're found liable for that he missed 3 days of work or temporary permanent disability.
In the case where the employee misses more than 3 days of work, I think they can. In this case, I don't believe Mr. Fink ever missed any work prior to this demand. If you look at the transcript, and it's not artfully asked on my part, but the adjuster did testify that Mr. Fink has not missed time from work from this injury. So this case is a little bit different than the majority of the cases that you file petitions on, where the employee's been off work for weeks, months, et cetera. In this case, I don't think Mr. Fink actually missed any time from work at this particular time, and would still stand by the allegations that there was no time missed from work or there was no permanent injury. And frankly, Your Honor, that's never been a contention on the part of the commission that Mr. Fink did in fact miss work or had a permanent injury. They never argued that throughout the entire case. That part's generally been conceded, and that's unusual to this case because most of the time the person has missed work. Had they missed work, the adjuster would have filed the first report of injury originally and we wouldn't have been here anyway.
Is there a conflict between Administrative Rule 3.1 and the statute 8611 that says no reports required unless they miss 3 days or more of work or have permanency?
There would be, depending on how you interpret 3.1. You can interpret 3.1 so that's not in conflict with 8611, meaning if you use the word and you say any first report demanded pursuant to 8612, which refers to 8611, if you interpret 3.1 so that it's valid with that statute, there is no conflict. If you were to interpret 3.1 differently, as the petitioners argued a little bit today, then I think there is a conflict, in which case I'd argue that interpretation would make the statute invalid, which would be an interpretation the court would generally not accept.
So we have a duty to try to harmonize the rule and the statute, and if we can't, the statute would prevail over the rule, right?
That would be my argument, yes.
so I understand what you're saying is the commissioner's interpretation of the rule is, well, you've got a statute that's, 8612 says the commissioner can require a report by agency rule. The agency rule says first report of injury is to be filed when demanded by the commissioner pursuant to 8612. And you're saying their interpretation renders the second part kind of maybe superfluous, what follows, and also just basically says the commissioner can now just require a report whenever they want to.
Correct.
Okay, and you're saying that doesn't really make sense.
Right, because I think that's, if you look at the word and you would interpret it 3.1 to say, first report demanded pursuant to 8612, you look at 8612 and says, first report required by 8611. I think if you use that first part and second part, first part being it's a report required by 8611, and there's original notice we're required to file.
But where it says 8612, commissioner can require the filing of a report by agency rule, your position is the rule has to be more than just the commissioner saying, I can ask for a report whenever I want. There has to be some defined set of circumstances.
Right, and especially in this case when 8611 is specifically passed by the legislature and defines this. Once you have a section that defines it that sufficiently, I think it's clear that that's what it's intended with 3.1. That's all I have. Thank you very much.
Ms. Baker? Ms. Berger, I'm sorry.
Your Honors, it's the Commissioner's position that consistent with its compliance duties, those obligations that it has to monitor and track cases, that it can require an employer under 8612 by written demand to file that first report of injury. The rule provides for it, the code provides for it. We would ask that the agency, that the district court be reversed.
Can you find somebody, though, if the report isn't required under 8611? That's the question I think that's here today.
Yeah, I understand, I agree, Your Honor, but we believe that the authority to make that written demand is in 8612, and in addition to that, it's in the administrative rule 3.13, that the commissioner, upon written demand, can request that first report of injury to track those inquiries, that it has a requirement under its functions and its duties to keep those compliance things in check.
Ms. Berger, you heard the dialogue I just had with Mr. Scieszinski. Is it the commissioner's position, the state's position, that under the existing structure of the statute and the rule, the commissioner can ask for a first report of injury at any time for any reason and fine the employer who doesn't provide it? Is that basically what it comes down to?
That is basically what it comes down to, that it does have the authority. Again, it's a tracking device. It allows the commissioner to maintain its compliance functions that it has within that agency, and it's simply a tracking device to keep track of that claimant and that inquiry that allows for the commissioner to comply with its functions and duties. The commissioner would ask that the district court decision be reversed.
Thank you very much. This case is now submitted, and we'll now hear from the case of State of Iowa versus McKinley.